Welcome, everyone. My name is Sam Agan with AcuTech, and I'll be moderating today's webinar. First, some information on the meeting platform. The navigation bar on the left includes a button to make the presentation full screen, a button to switch audio to phone, as well as a Q&A button to submit any questions you may have that will be answered at the end of the presentation. Today's webinar will discuss the implications of the recent ruling of the 10th Circuit Court in Galea versus Wynnewood Refining. Slide, please. Founded in 1994, AcuTech is a global leader in process safety and security, providing management and technical consulting services, world-class training, as well as enterprise risk management software. Today's session is based on a white paper that was written by and will be led by regulatory experts Mike Hazen and Mike Taylor. Slide, please. Mike Hazen is a technical manager for AcuTech with over 46 years of experience, focusing on all aspects of process safety management. He has led or participated in hundreds of PSM RMP audits, process hazard analyses, and security risk assessments. He has managed several major process safety management implementation projects worldwide, taught numerous process safety, security, and risk analysis courses, and has authored several process safety management books for the Chemical Center for Process Safety. Mike Taylor is chair for Greenberg Traurig's Labor and Employment Practices OSHA Group, with over 18 years of experience focusing his practice on representing employers regarding OSHA and CSB matters. Mike also has wide-ranging experience in the occupational safety field, including his prior public service as general counsel to Occupational Safety and Health Review Commission, the federal agency in charge of the trials and appeals of workplace safety and health disputes between federal OSHA and the regulated community. I'll hand it over to Mike Hazen now.
Thanks, Sam, and good afternoon to everybody. On the screen here, we have an agenda of what Mike and I would like to talk to you about during this webinar. We'll start with just a very, very brief recitation of the facts in the Wynnewood case. We'll spend most of our time talking about the 10th Circuit ruling, an overview of it, and what its meaning is to the PSM community. We'll also talk about how OSHA has treated or recommended treating utility systems in PSM programs in the past and how that compares to the 10th Circuit's ruling. We'll also talk about what we think could happen next and what the practical impacts are on facility PSM programs if the ruling that exists today stands as is. And finally, we'll talk a little bit about what possible impact could be on the EPA's RMP Rule. First, the Wynnewood case. In 2012, at the Oklahoma refinery, they suffered an explosion of the Wicks boiler system. This boiler explosion, resulted in one fatality. That boiler was connected to the refinery alkylation and FCC units, which are PSM covered. The boiler itself, however, did not contain a threshold quantity or more of any PSM covered chemical. As a result of the explosion, OSHA issued citations for the boiler not being included in Wynnewood's PSM program. Wynnewood appealed those citations to the OSHA Review Commission, and the OSHA Review Commission, although it took them 3 or 4 years, finally issued a ruling in 2019 in favor of OSHA. They upheld OSHA's citation for Wynnewood not including the Wicks boiler in their PSM program. Wynnewood appealed to the federal judicial courts, and in October of 2019, the 10th Circuit Court of Appeals in Denver agreed to hear the case. So that's the background. Now the ruling. On October 27th of this year, the 10th Circuit upheld the OSHA Review Commission ruling based on what they termed a plain reading of the wording of the definition of a process that's written in the PSM standard. And when appeals courts issue rulings based on plain reading, What they're saying basically is that they don't rely on any other interpretation or case law to support their ruling. This is the definition of a process that's in the PSM standard. And I've underlined the words and phrases that are crucial in this ruling. OSHA, for the purposes of PSM, defines a process as any activity involving a highly hazardous chemical. And that phrase that opens this definition is the crucial phrase that the 10th Circuit used. What's also important is the interconnectivity of any of these activities involving a highly hazardous chemical to each other. I've also underlined the phrase that follows that, which are located. In other words, separate vessels which are located such that a highly hazardous chemical can be involved in a potential release is also important in the definition of a process. Although in this particular case, it was the first phrase, any activity involving a highly hazardous chemical, and the interconnectivity. But I will come back to that proximity phrase a little later. Now, there are three, the 10th Circuit ruling was, dozens and dozens of pages. However, I'm going to focus on, in explaining what they ruled, what the ruling was, I'm going to focus on just three sections of it, or three parts of it. And the first you see here, and I'm not going to read this one verbatim to you. Again, I've underlined what we feel are the important words or the important aspects of the ruling. The first is that the court stated that a plain reading of the definition of a process unambiguously applies to the boiler. And they go on to say that that plain reading, once they've made that and understand what the words mean, if that meaning is clear, they need not look any further. In that part of their ruling, they refer to a Supreme Court case called Kaiser, and that's where the Supreme Court ruled on how regulatory language should be interpreted by the courts. But this part of the 10th Circuit ruling is important because it says that we made a plain reading of the definition of a process, that meaning is clear, and we don't have to look anywhere else.
Hey, Mike, and this is Mike Taylor. And one of the big issues in the case was not so much about any activity involving a highly hazardous chemical. That's kind of straightforward. What I do think was the key is, what does it mean to be interconnected? And that is where the dissent found that there was some ambiguity in what does it mean to be interconnected, because for example, your wastewater treatment facility could be interconnected to your covered process. In other words, where does it begin and where does it end? Okay.
The second part that helps explain the 10th Circuit's ruling is here. They examined the plain language of the definition of a process, and based on that examination of the language, they felt that the regulation could be enforced in accordance with its plain reading. Again, the court was not relying on any other case law or any other legal reference in order to make their ruling. The third part it's a little lengthy here on the screen, and I'm not going to read the whole thing to you. Again, I've underlined what we feel are the salient phrases. The court said that there's nothing on the face of this definition that requires a vessel to contain highly hazardous chemicals in order to be part of a process. They went on to say that any activity involving a highly hazardous chemicals, again, that any activity involving language captures a wide swath of vessels, in that they need only to be part of any activity that involves a highly hazardous chemical. Definition of a process unambiguously includes vessels which do not contain a highly hazardous chemical. And therefore, in the last underlined statement, the Wicks boiler may be considered part of a process, even though it did not include any highly hazardous chemicals. So, the key part of this ruling, in addition to the interconnectivity part of it that Mike just explained, is any activity that involves a highly hazardous chemical in the definition of a process in the PSM standard, and the interconnectivity, in this case, of the boiler to other processes that were already PSM covered, means, therefore, that any utility system that is connected to a PSM covered process should also, therefore, be considered part of the PSM program as well. So what kind of systems are we talking about? Anything that heats, cools, powers, or otherwise plays any role in the operation of a PSM covered process would then be considered an activity involving a highly hazardous chemical. Examples, common example, the ones that are fairly easy to determine: cooling water, compressed air systems, inert gas or purging systems, boiler and steam system, fire protection systems. Now, that's an interesting one in that fire protection systems are generally not directly connected to the processes that they support. And that's where we're going to come back to this proximity clause here in a few minutes. Electrical power. Electrical power is not a chemical. It's not air, steam, water, but it is connected, obviously, to a process, and that's what helps drive the process. So by including these systems that involve an activity involving a highly hazardous chemical, the scope of PSM coverage will likely widen in most facilities covered by the standard, if this ruling stands as it does today. Now, I've mentioned the proximity part of the definition of a process. Let me explain how this could be interpreted for other types of utilities, and I'll offer a couple of examples here in a minute. Now, the 10th Circuit did not explore or help define how a process that involves a utility system that involves proximity to a covered process how it should be interpreted. But there was a part of the ruling. It was in one of the footnotes of the ruling itself, and that footnote included a statement that said that they did not include the proximity issue in their reasoning because they didn't need it in this specific case, in the Wynnewood case, not because it isn't relevant. In this case, the Wicks boiler was connected to otherwise covered processes, and that interconnectivity was sufficient for the court's purposes in this particular case. Now, proximate systems or utility systems that are proximate to PSM covered processes could also certainly represent an activity involving a highly hazardous chemical. And the court did not exclude these from consideration. Here's an example. Let's say there's a facility, this is a fictitious facility, has a hot oil system. Hot oil systems generally operate at very, very high temperatures, 700, 800, 900 degrees Fahrenheit. And they supply heat to various processes. And in this case, let's say that the process that they provide heat to does not contain any PSM covered chemicals, okay? But because of the specific layout of this fictitious facility, if there was a release of hot oil and the fire that would likely result as a result of that release, it could damage a nearby process that does contain PSM covered chemicals. So the hot oil system doesn't connect to PSM covered processes, but it is close to PSM covered processes, so that a fire in the hot oil system could also affect the PSM covered processes. By the 10th Circuit's ruling, then the hot oil system could be interpreted as an activity involving highly hazardous chemicals, and therefore it should be included in this fictitious facilities PSM program, even though there's no direct connection. Another example of systems that have proximity, but perhaps not interconnectivity, and that's systems that might represent a latent failure with respect to the PSM covered processes. Now, what is a latent failure? A latent failure is the failure of a system or a piece of equipment, but it has no immediate effects on the rest of the facility. But because they're failed, then they are not available later when an emergency event occurs. A good example. Let's say that in an oil refinery, we have a fire protection system. They all have fire protection systems. Let's say that fire protection system fails. What happens? Nothing happens immediately, and nothing might happen for a long period of time if the fire protection system was down for a long time. But if a fire started in that refinery, then that latent failure would probably result in some sort of catastrophic event. So that's a latent failure. And again, fire protection systems are not usually directly connected to anything else in the plant. They're usually self-contained systems. So that's a description of the 10th Circuit ruling and what its meaning might be, or is likely to be, especially if it stands as is. So how does this relate to what OSHA has had to say about utilities in the past? For years, almost since the beginning of the PSM standard in 1992, OSHA has been stating in written interpretations and clarifications that utility systems that are important to process safety should be included in PSM programs. And you see three references here on three different occasions in the 90s and the early 2000s when OSHA replied back to questions on this topic. And OSHA's rationale was that if a utility whose failure could cause a PSM incident, or that utility safeguards against a PSM incident, then that utility should also be included in the PSM program.
So, Mike, yeah, so this has been a complete departure from what they've told the regulated community in the past in terms of utilities and interconnectivity.
That's right. And the 10th Circuit ruling.
Yeah, but somehow the 10th Circuit found that the wording was unambiguous, even though OSHA's own words and enforcement guidance over the years have said otherwise.
And the 10th Circuit did not rely on utility failure or success or anything related to that in making its ruling. It simply relied on what they felt was a plain reading of the definition of a process. Therefore, any activity involving a highly hazardous chemical is actually a broader ruling than OSHA's previous interpretations on utilities. And when OSHA issues enforcement guidance, if the ruling stands as is, it could be broader than those previous interpretations, which talked about utility failure. Another indication of OSHA's interpretation of how utilities be treated can be found in their request for information, or RFI, that they wrote pursuant to President Obama's executive order in the wake of the West Texas ammonium nitrate explosion that occurred in 2010. In that RFI, OSHA proposed revising the PSM standard to expand the applicability of the mechanical integrity element, just MI, to include all equipment that was critical to PSM as identified by the facility. This potentially could have included utilities that are critical to process safety. However, that RFI did not result in any draft revised regulations, The administration changed in January of 2017, and OSHA dropped the matter, at least then. But you can see from this that OSHA for a long time has held the opinion, they just didn't put it in the regulation, that utility systems are important to process safety. So what can happen next? Well, this case was heard by a 3-judge panel of the 10th Circuit, and that's typical at the federal appeals court level. The full court generally doesn't hear cases before a 3-judge panel hears them first. So the ruling that we have in front of us today was made by a three-judge panel of the 10th Circuit. So Wynnewood could decide to appeal to the full 10th Circuit. However, the full court is under no obligation to take the case. They could simply say that the 3-judge panel ruling stands as is. And of course, if they don't get satisfaction from the full 10th Circuit, Wynnewood could decide to file an appeal with the Supreme Court. And of course, same thing at the Supreme Court level. The Supreme Court's under no obligation to take the case, and they may let the prior ruling stand as is. We haven't heard, and we've been paying close attention to it, what Wynnewood's decision is thus far. Now, if the ruling, as we've explained it here today, stands as is, then the next important thing that will happen is that OSHA will have to determine how they're going to enforce the ruling. And that will be very important in determining what the practical effects on PSM programs on the ground in affected facilities will be. And what we'll do is we will explain what we think the practical aspects or the practical impacts of the ruling could be here in the next section. The first thing that facilities in the PSM community will have to do is determine the impact of utilities that interface with their PSM covered processes. So how are they going to do this? Where should they go to look? What analyses should they do, or records should they look at? The first thing that we recommend that a facility in this situation do is look at their existing PHAs. And if those PHAs were done in a complete manner, they should describe how utilities or the failure of utilities contribute to process safety events, or could contribute. So any failure of a utility or any utility that's a safeguard certainly would be a utility that would be a candidate for inclusion in their PSM program. The other place that they should look at is the original design purpose of each interfacing utility. Where to go to find that? Engineering records, project records, the original written design purpose of the facility or the process when the project that implemented it was approved. Those original design documents should give a fairly good idea of what the intention of all the systems that were included should be. So between those two sets of documents, and maybe others, a facility ought to be able to put together a pretty good list of the utility systems which would involve any activity or represent any activity that involves a highly hazardous chemical. In looking at the list of PSM program elements that are in the standard currently, we think the following ones that you see here, these 6, would be relatively unaffected: employee participation, contractor safety, hot work permits, incident investigation, audits, and trade secrets. Now, the incident investigation element may have to be widened a little bit in terms of which incidents or near misses to investigate, in other words, the ones that occur in utility systems, but how the incident investigations are done, how the root cause analysis is done, how the incident investigation reports are written, and those sorts of things shouldn't be affected by this ruling. But the scope of incident investigations may widen a little bit. So how about the rest of the elements? Well, those may be a little more affected, and we've tried to describe what we think the possible impacts could be. The first is process safety information. Nearly all facilities in the PSM community currently have basic process safety information that describes their utility system. In other words, pretty much they all have P&IDs of their utility systems, electrical one-line diagrams for the electrical power systems, and so forth. What may be missing, however, is a specific PSI called for in the regulation that may not be as well documented for the utility systems. For example, relief valve design basis calculations for the relief devices in the utility systems, safety system design and design basis information, and these sorts of things. We've also found that process safety information for fire protection systems may not be as well documented. That's a systemic weakness that we have found in helping our clients with PSM over the years. So there may be some PSI upgrades that may be necessary to fill in some of this missing information for the candidate utility systems. Process hazard analysis. Well-performed, complete PHAs, as I already said, should already address the effects of failure of the interfacing utility systems. What happens if we lose power? What happens if we lose cooling water, and the like? There should be scenarios in those PHAs that describe the causes, consequences, and all of the other information that you would see in a PHA hazard scenario. However, what we have found over the years is that very few facilities perform PHAs on the utility systems themselves. And the main reason for that is that those systems do not include PSM-covered chemicals. Sometimes we will see a PHA on those systems if the failure of that system or something could happen in one of those systems, and there are some PSM incident potential from a failure in one of those systems all by themselves. And there are several types of utilities in the PSM community where that's possible. I've already mentioned hot oil systems, and they operate at very, very high temperatures, and a release of the heat transfer fluid from one of those systems would likely instantly cause a pretty serious fire. Also, superheated steam systems. When failures occur in superheated steam systems, they have the likelihood of causing some pretty severe damage and some pretty severe health effects from anybody exposed to the steam. So there are a few systems that might warrant a PHA all by themselves, but you don't see that too often. Now, what will OSHA demand? We'll have to wait and see, but hopefully the need for explicit PHAs on all of the interfacing utility systems will not be required. And only those utility systems where there is a significant contribution to the process safety risk. But again, we'll have to see what OSHA has to say about this when they issue some written enforcement guidance. Operating procedures. Just about every facility that we've ever been in has operating procedures for the utility systems. They're all written down. They're usually fairly well documented. However, the requirements in the PSM standard for an operating procedure require certain other information, not just the steps in operating the process, safety and health information, description of safety systems, and some other things. Some SOPs for utilities may not include all of that information. So like with the process safety information, there may be some SOP upgrades here that will be needed fill in this missing information. Operator training. In general, operators are typically well trained on the utility systems. They have to operate them, so they receive the necessary training. But like the SOP element, operator training programs require specific things to be covered. So there may be some upgrades in the training programs for operators with respect to the utility systems. I don't suspect it's going to be a lot, but there may be a few things. Hopefully, though, this won't require any extra or special training, and it can be covered through the regularly scheduled operator refresher training, which is also a current requirement. So I don't think there'll be too much of an impact on that element. Now, mechanical integrity. We think that this element of PSM is likely to be the one that's most affected by the 10th Circuit's ruling. Any utility system that winds up being included within the scope of a facility PSM program will also have to be included within the scope of that facility's mechanical integrity program. What does that mean? Well, we'll need written maintenance procedures that describe the inspection, testing, and preventive maintenance and how to do it. The facility will have to choose what inspection, testing, and preventive maintenance tasks are relevant and what their frequencies are. So they will have to pay attention perhaps to several recognized and generally accepted good engineering practices that they didn't have to before. They'll have to formally manage any equipment deficiencies in utility systems, just like they do today for the main processes. And they will have to include the utilities within the scope of the MI quality assurance program. So spare parts management, project management, welding packages, welding procedures, PMI, positive material identification. All of those parts of the mechanical integrity program will have to be extended also to the utility systems as well. So what are these RAGAGEPs that I just referred to that are applicable to utility systems that now may become relevant for PSM-covered facilities? Well, the first one is that it's actually several of them. The National Fire Protection Association, NFPA, has a number of standards that describe the inspection, testing, and preventive maintenance of both electrical systems as well as fire protection systems. NFPA 25, for example, is a fairly comprehensive document that specifies the inspection and testing along with frequencies for all water-based fire protection systems. NFPA 70B is the maintenance supplement to the National Electric Code. And again, it's a very comprehensive document that has a host of inspection, testing, and preventive maintenance tasks for electrical distribution systems and electrical distribution equipment. There's a relatively obscure organization called the Cooling Tower Institute. And Cooling Tower Institute is an accredited ANSI standards developing organization, and they have a document called the Cooling Tower Manual. And it has inspection, testing, and preventive maintenance recommendations for cooling water systems. And of course, boilers are already regulated, including inspection and testing requirements in 48 out of the 50 states. So those should already be taken care of. If you have a facility in Wyoming or New Mexico, those are the only two states that don't regulate boilers. Okay, management of change and pre-startup safety review. In most facilities in the PSM community currently, management of change and PSSR have been extended and apply to all facility changes fence to fence, or nearly so. Those two elements, for one thing, they've been married together in many facilities. So PSSR is one of the last steps in an MOC. And in most facilities, as I said, the scope and applicability of the MOC procedure usually applies to just about any change in the plan. So we're not we're not thinking that MOC procedures will have to be extended all too much. But there may be some facilities that have a more limited applicability of their MOC program, in which case there may be some expansion of scope that will be required. Emergency response. Now, currently, emergency response plans cover all the typical kinds of process safety events that you can think of: fires, explosions, toxic gas releases, and the like. And they usually cover other types of undesired emergency events, naturally occurring events, even some security-related events. So releases, up till now, releases of utility materials themselves, water, steam, compressed air, and so forth, generally do not result in the same types of emergency events as fires, explosions, and toxic gas releases. And generally, they don't require the same sort of emergency response. However, as I've already stated, I mean, there are several types of utility systems where a release could be pretty severe. Superheated steam systems, as I already described, and hot oil systems, as I already described. A major steam explosion in a boiler would certainly be an event that would require the immediate attention of the emergency response team. So there may be some events that are not within the scope and are not described in terms of the response in the ERP. That they may be there may be some upgrades that are necessary. And of course, utility systems, the failure of them can trigger some fairly serious process safety events as secondary event. For example, the loss of power, total loss of power in a refinery is a design basis event, and the entire flare and venting system is designed with that event in mind. Loss of cooling water in certain types of chemical plants that are vulnerable to runaway reactions would be another example. Most emergency response plans should already cover those types of events, but if they don't, then some revisions to the emergency response plan may be required. So a review of the ERP at every PSM covered facility is in order to make sure that the primary and secondary effects of utility failures or events in the utility systems are addressed in the plan, and then upgrades if necessary. So that's a description of what we think the practical effects of possible changes to PSM programs that may result from the 10th Circuit ruling. The last thing that we want to talk about is the possible effect of this ruling on the EPA Risk Management Program rule. The first thing that has to be acknowledged here is that the EPA did not cite Wynnewood, OSHA did. And the EPA was not a party to the appeal to the OSHA Review Commission or to the 10th Circuit. However, the definition of a process in the RMP rule is identical to the process, to the definition of a process in the PSM standard. The same phrase shows up in both regulations: any activity involving a highly hazardous chemical. Now, that part of it may be identical, but the two regulations are not identical in every way. And their intent, of course, is to protect two separate groups of people: on-site workers in the case of the PSM standard, and the public and the environment in the case of the RMP rule.
Mike,
However,
Mike, the scuttle bucket that I'm getting from some of my contacts within the EPA is that they are very seriously considering piggybacking off of OSHA on this particular ruling, as they believe it was a correct one.
Okay. Well, we're going to come back to that point here in a second, and if there's something you want to add to that, you can. Now, that said, there's considerable overlap in the types of events, even though they're not, the regs aren't identical, and it's two different federal agencies. The kind of events that both of these regulations are trying to prevent or mitigate is essentially the same. catastrophic events do not respect the boundaries, the property boundaries of facilities. And so the same types of fires, explosions, toxic gas releases that can affect who OSHA is trying to protect, which is the on-site folks, will also affect off-site receptors as well. So that's a very, I think, an important commonality between the two regulations. And as a result of that, the programs within those facilities to prevent and mitigate these types of events are the same, particularly the prevention program portion of RMP. It is comma for comma, period for period, identical to the PSM standard. Now, it's undergone a fair amount of upheaval in the last 4 years. There were some revisions that were stayed, and then they went into effect. And then the EPA, ultimately about a year ago, reversed them all back to the original RMP rule that we've all come to know and love. But the programs within the covered facilities for RMP and for PSM are, at least the prevention portion, are essentially the same. And as Mike just said, EPA typically follows the same approximate enforcement scheme, and they may do so here as well for the RMP rule as OSHA does for the PSM standard. So the important questions, and Mike started to address these here just a second ago, is can a federal appeals court ruling made with respect to one federal agency be applied to another agency if their regulations are the same, or parts of their regulations are the same and they have the same purpose? And can one federal agency, in this case the EPA, use a court ruling in a case involving another agency, OSHA in this case, to interpret and apply its own regulations? From what Mike Taylor just said, it appears that they may be headed in that direction.
That's correct, Mike. And it would be considered persuasive, not binding, but persuasive authority in another lawsuit involving the EPA on, let's say, a different circuit. Unless, however, there's some negotiated rulemaking with the regulated industry and OSHA over this definition of what constitutes a covered process. Because I think that would bring fruit from what I believe to be a very poorly written decision, and brings a lot of confusion to the industry in terms of where does a covered process begin and where does it end. It would take, API, American Chemistry Council, AFPM, whoever, to form a coalition to try to do some negotiated rulemaking with OSHA to clarify this, so that it's easier to determine where the process begins and where it ends.
Okay, all right. Well, I would it be typical, Mike, for those sorts of coalitions to begin that sort of negotiated rulemaking after they see something in writing or before?
Either way, they could start approaching OSHA now, forming a coalition, and doing that. But the downside is that we have a new administration coming in, and I doubt that you're going to see a new head of OSHA until maybe the latter part of the summer. So they may have to wait until a new head's put in place, rather than dealing with the acting administrator.
Okay.
But I think that would be the best recourse for the regulated community, which would be some negotiated rulemaking and reword what a process is so that it's more understandable and clear, rather than what we found out in the 10th Circuit's decision.
Okay. Well, that's the end of our prepared remarks.
All
And
right.
now we'll be happy to answer some questions.
Yeah, thanks a lot, Mike. And Mike, that's a really interesting presentation, and I think that's just very applicable. As you just mentioned, Mike Hazen, we have a few minutes to discuss some questions from the audience. But first, I think on the same lines of what you guys were just discussing, I have a question that I'd like to ask myself. Is the 10th Circuit ruling, is it enforceable right now, or do they have to wait for any future potential appeals to be exhausted? I think you were starting to touch on that. Yeah, go ahead.
Yeah, it's enforceable now unless OSHA or Wynnewood file an appeal. What's interesting about this case is that Wynnewood got beat to the punch. And what do I mean by that? Well, Wynnewood filed an appeal with from the OSHA decision with the Fifth Circuit, but filed it 2 days late. OSHA filed with the 10th Circuit, thinking they get a better favorable ruling 2 days earlier. So there's this thing that called first to the courthouse applies. So that's why the 10th Circuit heard the case. Now, there is a very good chance of the whole 10th Circuit hearing the case in Bonk because OSHA lost on a very important issue dealing with repeat citations that we didn't talk about today, that they may be very concerned about in terms of how do you determine whether a new employer is really the same employer, and therefore we can issue repeats to that employer. So it's going to be interesting to see what happens and whether either or both parties petition the 10th Circuit for an en banc review.
Okay.
Mike, Hayes,
But
anything
Mike,
to add?
that happened. I'm sorry, Sam, but let me follow up on your
Yeah,
question.
please.
If OSHA turned around today and a field office, well, not a field office, but maybe headquarters issued some enforcement guidance, and a field office decided to march out into a PSM covered facility along the Houston Ship Channel, for example, tomorrow, could they write citations based on the 10th Circuit ruling as it exists today, or not?
Absolutely.
They could.
And that's what's troubling. That's why I think, a negotiated rulemaking, the faster, the better, to try to bring some clarity to this mucked up issue, I think.
So let me add on to that question. So if they were to issue citations, what issue would they be referencing? Would they be referencing this court ruling? Because it's not going to be the regulation right now.
Well, they'd issue citations saying you failed to have consider this a part of your covered process, and it would be valid until the 10th Circuit's ruling is overturned, particularly if it's in the 10th Circuit.
All right.
Are they limited to the 10th Circuit? Which is the pretty kind of the Mountain West area, but could OSHA in Houston, for example, which is not in the 10th Circuit, use this ruling and refer to it in the citation as the source?
Right, and then they litigate, and let's say they lose. OSHA does. Now all of a sudden you've got two circuits in conflict, which makes this case. It would make this case or this issue, if you will, right for Supreme Court review.
Mm-hmm. Now that probably militates against some OSHA office deciding to rush right out and do something about it right now. But as you said, they could.
Definitely.
It wouldn't be illegal. Okay.
All right. Let's keep going with that train of thought. Would this ruling, if it stands, supersede any previous decision like the Mere decision?
Well, in a way, yes, it already has, because the courts use the plain language according to them, and has basically sidestepped the Mere decision in a roundabout way.
Yeah, the Mere decision involved tanks that are storing flammables at atmospheric conditions. OSHA wanted to include them. The OSHA Review Commission said, no, you can't unless you change your regulation. This ruling applies to other activities involving highly hazardous chemicals. Yeah, I guess certainly an atmospheric storage tank could be interpreted as an activity involving a highly hazardous chemical, even though it isn't a utility system.
Correct.
There's
Okay.
other implications there. There's a lot of other implications. Okay. Going back to the previous discussion a little bit, how long should we wait for the ruling to stand?
You're fading out, Sam.
So let me repeat myself. How long should we wait for the ruling to stand?
Well,
that's saying,
both parties
Go
have 60 days to file a petition for en banc review for the whole 10th Circuit. So I think it would be December 27th, something like that.
Yep.
so would you advise, I guess, employers to begin rolling out PSM for utilities right now, or wait until this appeal period is over?
In the 10th Circuit area, if you're residing in the 10th Circuit area, I'd advise clients to go ahead and start considering utility as a part of your cover process. But I don't think OSHA is going to come in. Let's say you're not doing that, and they come in, they see you're not doing that. I think they're going to give you some leeway before you start including this stuff into your PSM program. Does that make sense?
Yeah, it does.
Because but by the time if someone comes in and you don't have at a place in Colorado and you don't have utilities part of your PSM program, I don't think OSHA is going to cite employers right away. I think they're going to give them some kind of leeway, 60 to 90 days before expecting employers to have this in a full-blown process. Does that make sense?
Yeah, I also doubt, especially given the transition that's going on right now between the administrations, and since OSHA is a part of the executive branch, that an OSHA field office all by themselves without headquarters provided written guidance is going to march out on their own. Yeah, I suppose they could, that one of them could, but I find that a little hard to believe. So I don't think we'll see any enforcement of this before the 27th of December, and maybe not for a while afterwards. But as you said before, Mike, it's possible. It's not illegal for them to do that. I just think from a practical, maybe even a political viewpoint, OSHA is probably not going to stick their neck out too far without having all their ducks in a row from headquarters first.
Mm-hmm.
Right.
All right. This next question is an interest. Sorry, do you want to continue?
Yeah. So in the interim, my thoughts are for the industry to work with OSHA now to try to develop a clear definition of what a cover process is and change the standard, or work with them on a compliance memo that deals with the very same issue without actually having to amend the standard.
Amending the standard, a laborious process, public hearings, and all the rest. But yeah, some uniformly agreed to enforcement guidance is probably the quickest way to get some salient and cogent guidance out there for the community to follow.
Definitely. All right. This is a tricky question, but I think it's very interesting because it's very applicable to a lot of facilities. What about an on-site or off-site cogeneration facility that provides steam and/or electricity to the covered process? These may be owned and operated by a different company. Would this then bring them into PSM coverage, even though they don't handle highly hazardous chemicals? I don't know that you have the answer for this.
If it's on one site and one location, based on this reading of this ruling of this unambiguous language the court found, I think based on what you're saying, I think there's a good chance it is part of the covered process.
Even if it's a different company, a different owner, a different operator. Yeah. Okay.
Yeah, I don't know who OSHA would issue the citation to, the owner of the cogen unit or the owner of the process to which it's connected. But Mike may be right if it's on the same site. If it isn't on the same site, and it is a different business entity that owns the cogen unit, then maybe not.
You know, a lot of these sites have just like a fence line inside the same plot plan, but this inside this fence line is a different owner operator, but it's really all the same facility. But it's a very interesting question. That could go either way. Really.
Pretty good twist on the situation here. That probably, and this is the kind of thing that OSHA, you know, when writing enforcement guidance, would have to address, because the 10th Circuit certainly didn't address that issue.
There'll be a way for OSHA to get 2 for 1.
All right, I think we got time for a couple more here. I don't know, let's see. How do you see the reaction from states with their own OSHA plans? So I guess on the state level, do you foresee any reaction from the state OSHAs?
Well, 25, 26 of the states are state plan states, which means OSHA has ceded enforcement authority of their regulations over to the state. In general, they follow. Well, they have to follow what the courts say to do. But in general, they follow OSHA's interpretations of the regulations, either verbatim or pretty closely, or in some cases they go far beyond. In the case of California and New Jersey in particular, they usually exceed. So I think they probably would do the same thing here. Some states would probably scratch their head for a bit to try to figure out what to do. Some would follow OSHA's guidance the same way as the federal enforcement would go, and some states, like New Jersey, might see this as an opportunity to extend their own PSM regulations. In New Jersey, that's called the Toxic Catastrophe Prevention Act, and actually extend the applicability of it to include utility systems. That's a good question. We'd have to see how the states react. I think it'd be a bit of a mixed bag. Mike, I don't know whether you have any experience with state enforcement.
Yeah, the gist of it is that the states have to be as equally effective in terms of safety, if not greater. So at a very minimum, to me, this ruling is the floor and not the ceiling. So you'd have to really compare the language of what a covered process is, let's say in California, compared to 1910.119. And if the language, I don't recall, but if the language is very, very similar, it's going to be viewed the same as what the 10th Circuit ruled it at, if not even more aggressive.
Right.
All right. Let's see. Here's another question. Why would contractors not be affected? What if you haven't included your utility contractors in the program, the PSM program?
That's a good point. The contractor safety program, the procedure, might not be directly affected, but whoever asked the question is right. If the utility contractors weren't even considered part of the contractor safety program, for the same thing, you have to review their safety performance before you hire them, and you have to keep the injury and illness records, for their injury and illnesses on site. All the things you would do for the other contractors, they would have to then be included. So there may be some expansion there. That's true.
All right. Let me ask one last question here. I'm going to reword it slightly. How does the one judge's dissent play into future appeals where they said it was ambiguous? Or do you see the one judge's dissent?
This is Mike Taylor. That could be very persuasive authority in, let's say, the Fifth Circuit. So let's say OSHA goes into a refinery or another covered process employer, finds the same thing, a utility was not part of the PSM program, issues citations, the employer contests, they lose at the review commission, and then they appeal to the Fifth Circuit. Well, the Fifth Circuit could very well piggyback off of the dissent's reasoning and disagree with the majority in the 10th Circuit, which again would give you a very ripe case for review with the Supreme Court, which would be an interesting issue, particularly since the Supreme Court hasn't taken up an OSHA related issue in a while.
Okay.
All right. Any other comment, Mike Hayden?
Oh, I'm going to defer to Mike Taylor's opinion on that. He's the guy with ESQ after his name, not me.
What's that? What was the question?
Well, this issue of the dissent. I'm going to
Oh yeah,
defer to your opinion on that one.
yeah. I think it was very persuasive authority. So I wouldn't be surprised if you see this issue again pop up in a different circuit.
All right.
All right.
Great. Well, thank you very much, guys. I believe that's all of our time. Please direct any questions that you may have or requests for how AcuTech can further assist you to info@acutech-consulting.com. And thank you very much for joining, and have a great afternoon, everyone.
Thanks, everyone.
Thank you.
Thanks.